Thank you, Daniel, for the nice introduction. Welcome to the talk. This is joint work with an interdisciplinary team with Daniel Woods, the lead author, University of Edinburgh, Josephine, Wolff, Tufts, and a lawyer, Daniel Schwarcz, from the University of Minnesota. My name is Böhme, and I'm from the University of Innsbruck in the Austrian Alps. We're dealing with security failures, and my question to you is, what's the best part of a security failure? Well, NIST has a standard for that. The best part of a security failure is that we can learn and improve in the future. This pretty much looks reasonable. This is what we as engineers always think, like document what happened and then improve. There was a focus group a couple of years ago where they found out that security practitioners do not always take it so seriously, and they do not really learn from past failures. While you could argue individually, it's very unlikely that the same failure happens to you again, so maybe you don't learn that much. But where you would expect that people learn a lot is collectively. And those people who pay increasingly for security breaches should have an interest that the ecosystem gets more secure. And who is this nowadays? Well, that's cyber insurers. Back in the day, more than 15 years ago, co-authors and I speculated that insurers could accumulate data which they mine to improve risk assessment and then suggest best practice mitigation strategies to their clients. What a vision. A couple of years ago, we heard a cry for help. Somebody from the digital forensics and incident response community blamed the insurance industry. Apparently, they are gatekeeping response work. The market is failed. And that got us interested in studying this ecosystem. And this is more or less how the whole study that I'm going to present starts, and I'm going to spoil and give you the result right now. The result is the insurers are not the cause of the problem. They are just smart enough to deal with what we call the real problem. And the real problem is not in the realm of technology, it's not in organizational processes, but guess what? It's how litigation works. For this, I want to go a little bit back and give you the background. Whenever a firm is victim to a data breach, then usually the customers who are affected by the breach collect lawyers and sue the firm. And then in common law, there's a concept that is called discovery. Discovery means that the plaintiff's lawyers have access to communications and documents of the breached firm. And discovery is a good concept because it kind of leverages or gives the same level playing field of information between both parties, and it keeps courts less busy because many, many cases are settled after discovery. Normally, discovery is limited to what is relevant to the case. The United States takes it broader. Here, everything that can be reasonably calculated to lead to the discovery of admissible evidence is affected by discovery. It's very, very broad. And of course, that exposes the victim firm. Sometimes, or almost always, victim firms also hire their own attorneys. And of course, the communication between the defendant and their own lawyer should be exempt from discovery. This is the first important concept, and this is the so-called attorney-client privilege. So some communications are exempt. And then on top of that, if the law firm hires other firms, for example, incident responders or forensics providers who do technical work specifically for defending the case, then this is also exempt under a so-called work product immunity. Okay, so if this is the situation, then of course people need to react to it. If I'm the victim firm, I still have a lot of reason to more or less limit what others can learn about my processes. So I, of course, want to contain the risk. I perhaps fear negative publicity and many other things. So the first thing victim firms do nowadays is, well, call a lawyer yourself. And then this lawyer, in turn, hires all the forensics people. So it is really important that the lawyer supervises them in order to benefit from this exception of the work product doctrine. This leads to what we call lawyer-led incident response, or another way of framing it is hotline incident response. To illustrate that, it's good to think of a timeline. So here we have the incident and then the time after in second, days, weeks, month. What you usually would expect, and what is, let's say, prudent planning, is that you prepare for incidents, then you monitor. If something happens, you detect, you try to contain, analyze, and then lastly, you improve. So this is what engineers would do. In practice, you see what is at the bottom. People prepare less to the extent that they don't prepare at all. And when something happens, they call a lawyer. The lawyer hires the response team. And then everything is turned around litigation. This has a handful of consequences also for the firms doing the incident response work. One of them is that they get onboarded in a crisis situation. So there's very little time to select the best supplier. There's very little time to negotiate. And here is where insurers come in. Insurers, who most often pay the bill also for response, have a say in who does the work. And the way they do it is when you sign up for a cyber insurance policy, you also get a panel of pre-approved and pre-negotiated partners for incident response, but also for lawyers, and also not covered here for communications firms. And so what we have done here, we have tabulated the number of firms on different cyber insurance panels. And this is what led to this complaint that apparently insurers are gatekeeping the IR work. But the true reason is that insurers react to the fact that they need to find teams of companies that are proven to work together, that have pre-negotiated rates and pre-negotiated conditions, and often the rates also come with a big discount of up to 30%. And then comes another challenge: what to write, how to document what you find. And here I want to go a little bit deeper and show you some data points. So as part of many semi-structured interviews, we came up with big tables with dots, semi-dots, and so on. And I don't want to go into every detail or even count something. I just want to give you a few quotes to give you some feeling of what kind of conversations we had. And these are all the lawyer interviews here. So maybe let's start first with the question, when are lawyers involved? Are they involved when it comes to contracts or perhaps to cases? No, actually, lawyers are involved very early on. So for example, once conversations are about where the firewall was set up and how things were configured happening, we, the attorneys, need to be involved. So something where you expect this is mainly something technical. Lawyers are on the call, of course, also charging this to the insurer. And this needs to be there in order to make sure that the work product doctrine can be used as an exemption from discovery. Now it comes to what needs to be written. So for example here, if you get on a scoping call with a client and they don't have multi-factor authentication enabled or their password is just password, you never comment, especially in writing, on how good their data security is. Because, and I think that's very revealing, because the emails if all the emails get out in discovery, then you have set up your client for failure. This is something the industry knows. If you talk to digital forensics people, they also say, well, in principle, IT directors can strategically use forensics reports to win internal resources, but this cannot happen if I only deliver to counsel. And this here you already see an indication that the flow of information, the information sharing is not as good as it could be. There's two other interesting rows here in this chart, and these are the rows of how confident the attorneys were in whether the attorney-client privilege applies, and hence the information can be protected from discovery. And you see that there's a big mixed picture. And the reason for that is that we collected this data last year. And there was a big turning point in the industry. That was the case of Capital One. Capital One was an early adopter of a public cloud strategy and faced a big data breach in 2019, affecting, I think, in the order of 100 million US customers. Here you see 30 gigabytes of credit application data exposed. We don't need to really think about the technical details. All this is in a paper referenced on the bottom. What matters is that the legal consequences. A court ruled here that the incident report made by the forensics firm is discoverable, And the reason for that is that it was driven by business and not purely legal needs. So that essentially means the whole defense strategy turned out not to work. And as a result, we went back from this situation to, let's say, this situation. What do? Well, you write even less reports. Yeah, so here, when we directly asked about what happened in relation to Capital One, I've started to advise against written reports at all, and this also resounds here. There's just less reports written than there used to be. And if we talk to a regulator, just to get a different perspective, then this regulator says, we sort of half-heartedly ask, is there a report? But it's evolved to a point where most of the time they have not written a report, and that's a shame. All right, let me summarize the story. Insurance has improved incident response planning or compensated for the non-existence of planning, in particular for small and medium-sized enterprises. The technical best practices and everything we more or less teach at engineering school collide with the, in particular, US litigation system. I don't want to be too critical, however, about the lawyers. Lawyers are not the adversaries. Yeah, they provide some useful services. Many, in particular, when they are specialized on incident response, know exactly what they're doing. And we don't want to evaluate the net impact of lawyer-led IR in this paper. We mainly want to depict the situation. But our conclusion here is that one consequence of lawyer-led IR is that it introduces barriers to how firms and also the broader community can learn from security failures. And this is why we chose lessons lost as the theme of the paper. A quick note on the methodology, and this was a multi-year, multi-stage, multi-method approach inspired by grounded theory, where you essentially consider everything as data and also make plan changes during the process. Altogether, we conducted about 70 semi-structured interviews covering different parts of the market, and we talked to largely all big players in the market. And perhaps the most innovative part was that we had a validation session under Chatham House rules ran during the pandemic over Twitch. So here you see my co-author Daniel and myself moderating the session. Industry participants could respond in chat pseudonymously. And for us, this is a great research artifact. And for these participants, it was perhaps a business reason to use Twitch. Thank you very much for your attention, and I'm appreciating your questions.